BYJU'S Exam Prep IAS has been the gateway to your IAS prep. Our YouTube channel is going to get even better from 2023. Starting 2nd January, the Hindu newspaper analysis will be conducted live every day at 10 a.m. by your beloved faculties. Not only this, we have a whole new set of initiatives lined up for the new year to help you clear this prestigious exam. So subscribe to our YouTube channel now and give wings to your civil services dream.
Hello and welcome to Byjus Exam Prep IAS. Before we start with our today's analysis, we have two important announcements. Tomorrow being 1st of January 2023, we would not be uploading big news, daily quiz and CNA on our YouTube channel. Wish you all a happy new year in advance. On 2nd of Jan 2023, our CNAs will be live at 10 a.m. So watch us live on our YouTube channel at 10 a.m. the following CNAs from 2023. Let's get started and look into the first article. The first article says a strong case exists for marriage equality. Let us try and understand what is this article all about. This article here is speaking about same-sex marriages. We have number of petitions that are filed in the Supreme Court of India. These petitions will be heard in the Supreme Court of India. However, there are a number of parliamentarians who have also said the same-sex marriages are against the cultural ethos of our country. In this particular backdrop, the question that the author is trying to ask is whether same-sex marriages come under the legislative domain and will it also come under the judicial domain? Can the judiciary pass a judgment? Let's look into the arguments as to what the author goes on to say. When it comes to the same-sex marriages, as of now, it identifies heterogeneous couples, which means a man and a woman, in case they want to get married, if they are from two different religions, such will be identified under the Special Marriage Act of 1954. But the petitions that have been filed in the Supreme Court of India is seeking for identifying same-sex marriages. It can be gay marriages, it can be lesbian marriages. So if it is between the same sex, this also has to be identified under the Special Marriage Act is the petition filed in the Supreme Court of India. This is where the author goes on to say that if it has to be identified, it should come under the legislative domain. Why? Because it is the legislature who have to introduce such terms in the legislation. Does the judiciary have the power to look into it? This is where the author goes on to say yes, the judiciary does have the power. It also takes into picture the comparative laws in multiple other countries. It also takes into picture the previous precedents that have been declared by the Supreme Court of India. This is where the author brings into picture two important articles. One is this needs to be seen in framework of right to privacy. The other is in the framework of right to equality. If it is viewed from the viewpoint of right to privacy, it means it is going to be an individual case. This is not to do with society as a whole. So if you are speaking about the individual level, the state would not be able to interfere. If you are speaking about right to privacy, which is an aspect of Article 21 under right to life and personal liberty, it speaks about personal liberty. Personal liberty has an aspect of privacy, so the state cannot interfere when it comes to the right to privacy. That's one point. The second point is in terms of equality. If we say the heterogeneous couples and the homosexual couples are the same, if we go on to say that same-sex marriage is equal to that of heterogeneous couples marriages, in that case it is about right to equality. Both are the same. This is where the state can come into picture. So on one side, if it is right to privacy, the state cannot come into picture, it cannot interfere. And if it is to do with right to equality, then the state can interfere, and the state, that is the legislature, can also impose a ban. So the author goes on to say that there is one side where the state can interfere, there is on the other side the state cannot interfere. So how do we put out this dilemma? How do we answer this confusional part? This is where the author brings into picture the international jurisprudence. What is this international jurisprudence? Jurisprudence is a study of law. Law basically is, if you have a criminal law Why is that a particular punishment is being awarded for that particular crime? So this law is studied at an international level. You also study law from a different society perspective. You also study law from the progressive point of view with changing times as well. All this is part of the international jurisprudence. So jurisprudence is the essence of why you have to study law. If you compare number of countries, what have countries considered about the same sex marriage? What we have to look at is one of the judgments given in Dudgeon versus UK. What exactly is this case all about? We have section 11 of the Criminal Law Amendment Act of 1885, which criminalized male homosexual acts in England. And at the same time, we also have the European Court of Human Rights, which said that such law which has criminalized male homosexual acts is violating European Convention on Human Rights. So this law was not in compliance with the European Convention on Human Rights, said the European Court of Human Rights. So it struck down the offence of burglary in North Ireland as violative of Article 8 of the European Convention on Human Rights because it disproportionately restricted personal and family life. This restriction cast on the most intimate part of personal life could not be justified by pressing social need. The court thus adopted a privacy approach and it did not go into the question of equal treatment under Article 14. So what does this judgment speak about? This judgment viewed the same-sex marriage from the perspective of privacy. So if we are speaking about privacy and if the Supreme Court can give this judgment, according to international jurisprudence, yes, the Supreme Court can look into it. The societal aspect, whether the state can interfere or not, was not taken into picture by this particular case. All that this case was decided that it is to do with privacy. What happens within that four walls is to do with the people. So the state cannot interfere in the privacy aspect. So in this judgment, what it went on to say was privacy was taken into consideration and not the societal conservative value system that was imposed from the society perspective. So whatever the society is doing, that is not to do with what happens within the four walls. So privacy was given importance in this judgment by the European Court of Human Rights. First judgment. Second is what we have to look at from the South Africa's perspective. On the contrary, a conscious decision by LGBTQ lawyers and activists in South Africa to litigate rights based on equality. So the first principle that we focused on was about Article 21, which is about right to privacy. So international jurisprudence from the privacy point of view says it is well and good. Now what are we going to discuss from the equality point of view? What did we discuss about equality? State has the right to interfere if it is to do with equality. But in such a situation, there is a case law in South Africa which says even from the equality point of view, the state will not be able to interfere, and this is where this judgment clearly clarifies. This judgment goes on to say, made sure they won successive battles beginning with constitutional protection of sexual orientation, judicial recognition of marriage, adoption, etc. Dealing with decriminalization in National Coalition for LGBTQ, Justice Ackerman compared the privacy and equality approaches and opined how the latter, that is, the right to equality, was enabling and granted greater protection to the homosexual persons. So, right to privacy is important, and at the same time, right to equality is also important. Right of equality is nudging, pushing, encouraging the right to privacy. If there are heterosexual couples, these heterosexual couples and homosexual couples are equal, said the Supreme Court or the Constitutional Court in South Africa. Thus, in Fowry in 2005, the Constitutional Court rejected the state's argument that the Constitution only protected the right to establish family in private life without state interference and not to marry. But the Constitutional Court said exclusion to marry was considered antithetical to equality and dignity. Permitting it would have meant that marriage of a homosexual couple was inferior or of less worth. This was constitutionally impermissible, said the Constitutional Court in the South Africa. So they went on to accept that same-sex marriage is equivalent to heterosexual couples and this is equal to right to equality, said the South Africa court. The US dealt with this cases quite differently, since it decriminalized same-sex relations and granted marriage equality both under the Due Process Clause of the 14th Amendment of its Constitution, which prohibits the state from taking away personal liberties without substantive and procedural fairness. The focus was thus on personal liberty from the United States of America's perspective. All these case laws from the international jurisprudence perspective clearly points out to say that when it comes to same-sex marriages, the judiciary has the power to interfere. It is not a legislative domain alone. The Supreme Court would be able to interfere and would be able to pass the judgment. Another reason being, we have the Supreme Court of India, which has already adopted the South African approach in Navtej Singh case. The top court read down Section 377 IPC, decriminalized consensual sexual conduct on the basis that it created an unreasonable classification for the same-sex persons under Article 14, besides being violative of the bodily autonomy under Article 21. Since it is violating bodily autonomy, which is to do with right to privacy, it is they who gonna decide, and if you are treating these two couples as different, it is also violating Article 14, said the Supreme Court of India. Added to it, when we speak about discrimination, if we are discriminating them, not allowing to live their life with liberty, in that case, it is also violating Article 15 of the Indian Constitution, says the author. So, given all these important case laws and the previous precedents laid by the Supreme Court has the power to come up with a judgment to identify and recognize the same-sex marriage. And going forward, this will be a landmark judgment if the Supreme Court so decides, is what is this article all about. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says the other side of sanctuary. The article here is speaking about the eco-sensitive zones. What is the context? We have the Supreme Court which had issued a direction that every protected forest, national park and wildlife sanctuary in the country should have a mandatory eco-sensitive zone of 1 kilometer starting from their demarcated boundaries. What do we mean by it? Let's assume for a moment that this is the national park, or let's assume for a moment that this is the wildlife sanctuary. This is the boundary, and from the boundary of the national park and from the boundary of the wildlife sanctuary, 1 kilometer in and around, there should be no activities related to the human beings. So basically 1 kilometer from the boundary of it, in case there are some human habitations or there are some activities, commercial activities, there should be no such activities. In case there are farmlands, in case there are agricultural plots, should also be taken by the government, said the Supreme Court of India. Now the question is, what are the eco-sensitive zones? As per the National Wildlife Action Plan 2002 to 2016, issued by the Union Ministry of Environment, Forest and Climate Change, land within 10 km of the boundaries of national parks and wildlife sanctuary is to be notified as ecologically fragile zones or eco-sensitive zones. And this 10 kilometer rule is not implemented as a general principle. Let's say, for example, if there is a national park or there is a wildlife sanctuary, in both these cases there are few sensitive areas in and around them. So this 10 kilometer can also be extended if a rule is also made by the state governments as well. So it is not a hard and a fast rule that 10 kilometers, but it can also be extended in case that particular area has some sensitive corridors. So what is this eco-sensitive zone? It is the transition zone. It is that zone where no human activities will have to be conducted according to Supreme Court. It is now for about 1 kilometer, but if you look at the original definition, it is 10 kilometer, and it can also be more as well if there are some sensitive corridors. Why are these eco-sensitive zones created? According to the guidelines issued by the Environment Ministry, ESZ are created as shock absorbers for the protected areas to minimize the negative impact on the fragile ecosystems by certain human activities taking place nearby. Furthermore, These areas are meant to act as a transition zone from areas requiring high protection to those requiring lesser protection. To give you an example, we know for the fact that Western Ghats are sensitive areas. There have been human activities that are conducted in the Western Ghats in some states as well. So what exactly happens? We go about building resorts, we go about conducting commercial activity in these Western Ghats along the mountain areas. So when there are heavy rain that occurs, this results in flooding, this results in landslides as well, and it is the people who become the major sufferers. So to prevent all this, what we require is the eco-sensitive zone. And the guidelines further go on to say that this is not to hamper the daily activities of the people living in the vicinity, but it is more so to protect their rights in that particular area. So guidelines will have to be followed so that commercial mining, sawmills, commercial use of wood are completely prevented and felling of trees does not happen in this particular area. So what did the Supreme Court say in June 2022? It went on to say that states and union territories will have to take the assistance of one of the governmental agency for satellite imaging or photography for the purpose of preparing this list so that that 1 kilometer buffer zone or the eco-sensitive zone is created. So we have the Kerala government which also took the support of Kerala State Remote Sensing and Environment Center. So this Kerala Remote Sensing and Environment Center identified 49,330 existing structure using satellite images, including 14,771 residential buildings and 2,803 commercial buildings within this 1 kilometer zone. The KSR SEC had also reported that 115 villages in Kerala would come under the buffer zone of the protected areas of the state. According to its report, a total area of 1,588 square kilometer would come under ESZ. The sanctuaries and national parks in the state are spread over an area of 3,441 square kilometer. The assessment found 83 tribal settlements were located within the ESZ of the state, with several organizations of farmers, factions of the churches and political parties protecting against the inaccuracy of the study. The Kerala government was also forced to appoint an expert committee headed by Tottathil Radhakrishnan, a former Chief Justice of Calcutta High Court, for field verification of the report. Now the question is, when this notification was released, after this report was released, there was a lot of hue and cry and there were protests by the people in the state of Kerala. That is because the farmers felt that the government will take away these lands. This will make them landless as well, and ultimately they would not have any source of livelihood. And at the same time, the minute this particular report came out as well, the land value of all their lands immediately plummeted. It immediately got reduced as well. They wanted to move to the urban areas selling their lands, but with this particular report they are not able to sell their land as well. So on one side they are apprehensive that their lands will be taken away by the government, on the other side they are not able to sell it as well, and with this number of areas in the rural areas they are not able to make a living, they are not able to generate enough sources of revenue, and some of the children are not able to study as well if this particular land is taken off. So what has been the response of Kerala government? Kerala government has said that it will safeguard the interests of the farmers, and at the same time they are also planning to approach the apex court. So the apex court, the Supreme Court, will also hear their case as well, and at the same time the state will also make use of the aerial survey report and highlight the density of the population in this particular area, and also suggest to the Supreme Court of India about the overwhelming public interest as well. So we have to wait and watch what will the Supreme Court do when it hears this case once again. Now let's look into the next article. This article says Precipice of Shame. What is this article speaking about? The article here is speaking about the recent instance that happened in Uzbekistan where syrups that were exported from India when consumed by the children have passed away. Similar such instance had also happened in Gambia as well. So this article goes on to say that India is known as the pharmacy of the world. Why? Because we are able to provide affordable, cheaper, generic medicines and export to multiple countries who cannot afford costly medicines. So what we were able to prove is to the world that we are the pharmacy of the world. In 2021, we were also able to export vaccines as well. We also developed vaccine Maitri as well. This was also the vaccine diplomacy that India was able to achieve. But fast forward to 2022, our reputation is at stake because of issues that has happened in Uzbekistan as well as in Gambia. We did recently discuss as part of the big news what this issue was. But what this article goes on to say that when such incidents occur, it becomes very important for us to identify who the perpetrators of this particular issue is, what went wrong in this particular ecosystem, was there any industrial solvent that was present in this particular syrup, who is supposed to be blamed, what are the measures that have to be taken so that this does not reoccur in the near future. This is how we have to take care of such issues. However, instead of identifying the loopholes in the system, we were trying to give lessons to the World Health Organization saying that these contaminants were not part of our medicines. We also said that this is to create a black image of India. Maybe this could have happened, but at the same time, while we also said that this has created a black image of our country, we should have also investigated the root cause as well. If the people are so involved in this particular case, they should be thrown behind bars. There should be new regulatory measures that have to be taken. So instead of doing this, we are only going about blaming these people, says the author. In fact, India has a tumultuous history of DG contamination. What is DG? Basically, we are speaking about diethylene glycol. So in the past, we've also had ethylene glycol or diethylene glycol, which have also been used in syrups in India as well. This has to be corrected. So India has a tumultuous history of DG contamination in medicines. Between 1972 and 2020, India has seen at least 5 mass DG poisonings in Chennai, Mumbai, Bihar, Gurgaon and Jammu. The incident in Gurgaon led to death of 33 children and the incident in Jammu of at least 11 children. The final reported toll in such cases is indefinitely an undercount because it is notoriously difficult for doctors to diagnose such deaths and attribute them to the adulterated medicines. So in all these cases, whosoever is responsible, they should be thrown behind bars, and we have to make sure that we have a regulatory assessment of such cases, says the author. So what is the measure that we have to take? This means that we have to trace the origin of the contaminated industrial solvent that is used to manufacture the syrup and ultimately hold them accountable. So rather than deny and attack mode, the Ministry of Health and Central Drug Standard Control Organization should ideally investigate and punish those responsible for deaths in Gambia, Uzbekistan, is what is this article all about. So basically, it goes on to say that mistakes might have occurred, but it is for us to take up corrective measures so that our image at the global level is not maligned. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says India Saudi Arabia discuss treaty on mutual assistance for criminal investigations. What is the context? We have India and Saudi Arabia who are in talks to sign a mutual legal assistance treaty to obtain formal assistance from each other for investigations related to the criminal cases. What is this mutual assistance? Mutual assistance basically means a mechanism whereby countries cooperate with one another in order to provide and obtain formal assistance in prevention, suppression, investigation and prosecution of crime to ensure that the criminals do not escape or sabotage the due process of law for want of evidence available in different countries. What is this mutual legal assistance treaty all about? This basically means that one country enters into a bilateral treaty with another country whereby both these countries exchange information with respect to the criminal matters. In case there is requirement of evidence in one country, the other country will provide suitable evidence that is required. So what they enter is into a treaty so that they can exchange the information, and ultimately these criminal incidents are controlled over a period of time. So Saudi Arabia in the past has deported several terror suspects on India's request, and now if this particular treaty is signed, what we will have is an increase in the conviction for an accused in the court of law. Added to it, we have to know the difference between mutual legal assistance treaty request and the letters rogatory. What is this mutual legal assistance? We just discussed that countries come together, they sign treaty as well. So when treaties are signed, that is what is called as mutual legal assistance. So one country, its external affairs ministry will make a request to another country. So there is treaty that is signed between one country and another. But what happens in letters rogatory? In this particular case, court that is present in one country, let's say the Supreme Court of India or the High Court of relevant states, they issue a letter requesting that such person should be investigated. So letters rogatory are the letters that are basically sent by the court of one country to the court of another country for obtaining some assistance or prosecution of a criminal matter. When it comes to mutual legal assistance, we require what is called a signing of treaty. So India will have to sign a treaty, and this can only be made to countries with which India has a bilateral treaty or a multilateral treaty agreement or an international convention. But when it comes to letters rogatory, India can issue to any country despite not having any treaty as such. So this can be given even if we do not have the treaty. But when it comes to mutual legal assistance, what we require is the treaty in most of the cases. Now let's look into the mains practice questions. There is a growing need for the government to grant legal recognition to same-sex marriages. Discuss. Cough syrup deaths will impact India's reputation of being pharmacy of the world. In the light of the statement, how do we hold pharma companies responsible? Examine. Please write all your answers on the comment section, peer review, and do give positive feedback to your friends' answers. So this is it for today. Thank you for watching and wish you happy new year in advance.